forgot my earphone. Hello. Hopefully everyone can hear me. Well, greetings on a Sunday afternoon, and thank you for tuning in for another class to learn about immigration law. So we're going to wait for people to trickle in a little, and when we do that, I wanted to remind everyone to follow me on Facebook and join our group. And again, the group is U.S. Work Visa and Green Card and Citizenship Help Group. So join that group. I'll try to post the link on the video. So we're going to have, we already have like 1,000 members in there, and I try my best to answer everyone's question as soon as it's posted. And we will get rid of all the spammers, so there isn't going to be a lot of spamming going on in that group. So follow me and choose See First, so that every time I go online, to do a live video, then you'll be able to know, you'll get a notification on your phone or on your laptop that says, hey, Jack is going live. Then you'll be able to tune in if you want to. So follow me, See First, and then join the U.S. Citizenship U.S. Work Visa and Green Card and Citizenship Help Group. I have my laptop here and I'm just looking at the notes. So while we're waiting for people to trickle in, I'm going to also log in as myself. That way I am able to see all the questions that people see online. So as people ask questions, then I'll be able to see them. Okay, so all right. Okay. I should be able to see myself. Oh, there it is. Okay. So, continue, expand. Okay, and I'm going to mute myself so I don't hear myself talk, and I can see the questions. Jason, hi Jason. Jivan, hi Jivan, and hi Vineet, I'm doing well, thank you. So today we're hopefully going to be able to cover both topics. It's quite a lot. I didn't write a lot of notes, but hopefully, we're going to be able to get through as much as possible. And also we'll have a Q&A at the end, just like last time, so that people can ask questions and I'll be able to answer them. So please save your questions until the end if you can. Okay, so lately I've been getting a lot of questions about the 60-day grace period for H1Bs after they're terminated from their employment. Everyone asks me, when does my 60-day grace period start? USCIS provided this new 60-day grace period that didn't really exist before 2017. They've always kind of quietly said that there is a 60-day grace period. Well, there's some grace period for you to change employer, and they'll still give you, the I-94 so that you can transition to the new employer without having to leave the country. So the only issue really about the 60-day grace period is whether you have to leave the country or not. You can always file another H1B petition even after the 60-day grace period. So let's get that out of the way, because I get a lot of questions where people ask me, oh, if I don't file the petition within 60 days, then I'm going to lose my H1B and it's gone. No, that's not the case. So you can always file another H1B petition, even outside the 60-day grace period. The only question is, would you have to go outside the country and then come back in to be able to activate that new petition? Technically, well, realistically and legally now, if you file it within the 60-day grace period, USCIS has to let you connect your last H1B status with your new H1B status, so you don't have to leave the United States. And how they do that is they give you an I-94 on the new petition approval. It says, you're approved, here's your new I-94, it's good for another 1 year, 2 years, 3 years, depending on how long the project is, that, is provable in your H1B transfer petition. So then that begs the question, when does my 60-day grace period start? Well, a lot of people don't know is that this concept is quite fluid, because it's it is whenever you say it starts. And I think people are quite familiar with the concept that if you delay your paycheck stubs till later, then your 60-day technically can start later because USCIS looks at pay stubs as the primary evidence of how long and until when you have maintained your H1B status before termination. So some people negotiate with their employer to have some severance pay, in the forms of a paycheck, and they delay that payment until later so that USCIS can use that evidence and say, well, I think we agree with this person that his 60-day grace period starts later than earlier. So having the right evidence definitely matters. And this is where a lot of people ask me, well, what kind of evidence do I really need? Well, I mean, you really just need your pay stubs because USCIS really only want to see pay stubs because being paid is evidence of maintaining H1B status. They don't really want to see anything else. Some people submit some kind of a termination letter. Some people submit some kind of payroll records or a letter from the company and all of that. Well, I would say just make sure that your paycheck, has the latest date. Because if you submit a bunch of evidence, it's only going to create this confusion for a USCIS officer. Because if I'm an officer and I'm an ass, I would say, well, this other evidence shows that you were terminated on this date, so maybe we should start, the 60-day from that day. Because the 60-day really starts whenever it's backed up by evidence. So if you give them one thing, and that one thing says that your 60-day starts on this day, then they would pretty much have no choice but to find that your 60-day starts on that day because they don't have any other evidence to suggest otherwise. So, the 60-day is whenever you want it to be. So definitely if you're leaving employment, if you have a choice, if you have some power left to negotiate with the employer, you want to defer your paycheck maybe till later so it gives you a little more time to find another employer within the 60-day grace period. Now, I mean, some people are going to be already outside the grace period. Then what do? I mean, they can still file a petition. Remember, at the end of the day, it only matters if you have to leave outside the country to come back to activate a new petition or you don't. So it's not really like life or death, but right now, it is quite an important issue because people can't travel. They can't go back home, and it's difficult to get into Canada. They have to go to Mexico, and no one wants to go to Mexico. It's like no one knows anyone there. So if we could prefer, also because the airports are quite dangerous, and taking a plane ride at this time is just not advisable. So we would prefer not to leave the United States when we file our transfer petition, and I'm sure that resonates with everyone who is sort of on this boat. So we're going to kind of talk about what are some of the things that you should know about this 60-day grace period. So we covered how does USCIS calculate a 60-day grace period, and just to recap, they calculate it from the evidence that your next employer provides to them about when your employment was terminated. So if you have conflicting evidence, try to choose the best one that has the latest date and decide if certain evidence is not necessary. Because if it's not necessary and it has a different date, it creates confusion. So you definitely want to avoid confusion. So you don't want to submit evidence that might give USCIS officer any other idea about your termination date. Okay, so letter B, how do I help my next employer make the best argument that the transfer petition is filed within the grace period? Well, usually I write a letter. I say, well, based on the 2017 memo, H1B has a 60-day grace period. Just kind of start from the beginning. Some officers might be really dense. They don't really know about the 60-day grace period. They should all know. But just start with an intro like, hey, this is the 60-day grace period rule. Look at this memo. And H1B status, ends when employment is terminated. And employment is terminated on this date. In this case, look at this evidence. So it has this list, it's like a letter explaining the rationale behind why you pinpoint to a certain date as the start date of the 60th day. Now, that date should be backed by evidence, and if it's supported by evidence, then it should be accepted. And you can give that letter to the new employer counsel, and they will use it and put it in the file, and hopefully they do. Some of them don't. I mean, I would always use it. Like if my client, who's the employer, gives me something that the employee writes, I'll read it and I'll be like, that makes sense. I mean, if I don't agree with it, I would usually reach out and say, well, what about this? This and that. So there's a discussion. But I understand that in a lot of the IT community, that the employer does not really have they don't wish to have this discussion with the employee. So all you can do is outline your argument with evidence, send it to the employer, and if I'm an attorney and this saves me time, I don't have to make the argument, I can just attach and send it, then I'll use it, right? I mean, anything that saves me time makes me money. So, if you are trying to help your employer's lawyer in making the best argument for you about the 60-day grace period, write something up, back it up by evidence, and say, here's my, within the grace period sort of summary. And if you're really within 60 days, like there's no argument about it, then, don't worry so much about it. But if you're like right on the cusp of 60 days, and it's arguable whether you are or not, and that's where the letter might be most helpful. And if you're way outside, then you'll write a different letter, and we'll talk about that. Okay, so C, how do I use COVID-19 and travel restrictions to my advantage in requesting a late filing if I'm filing my next H1B petition outside the grace period? So that's what we're going to talk about now. So if you're definitely outside, like if you're on the 90th day and there's no doubt that you're outside the grace period, I mean, I would still write a letter, but then I would say, well, I'm going to request a late filing because USCIS now allows late filings for petitions and because of COVID-19 situation. And you definitely want to make some kind of connection between COVID-19 and your loss of employment. For example, my employer had to do a mass layoff because of COVID-19. If there's any evidence to suggest that, like internal memos or any kind of online articles that you can print out and attach to that, and just make the connection between COVID-19 and why you lost your job, and then you could say, we're requesting a late filing. And I get questions about this, and some people ask me, what's the difference between a non-pro-tunc and a late filing? Well, non-pro-tunc applies only when your I-94 is already expired. Now, in our scenario, we're assuming that you lost your job halfway, but your I-94 actually is valid for like another year or another 6 months. Like you're not completely out of status, you're not accruing a lawful presence, you're just out of a job and you need to transition. And that's where the 60-day grace period comes in. Remember, if your I-94 is expired and you don't have an extension pending, then you're completely out of status. And that's not a grace period situation. It's not a 60-day grace period situation. So one must make that distinction very clearly. The non-pro-tunc, that's NUNC, and there's the late filing, which covers, the grace period. So in the letter that you'll write, you would say, I'm filing an H1B petition to request my extension. It's a late filing outside the grace period. You don't want to say outside the grace period because, just say late filing, and it's due to COVID-19. And when we've done that, and for clients who are outside the grace period, if they're outside for the most I've seen is I had a client who was outside grace period for 30 days. And, this was recently, of course, and we didn't think that, the late filing was going to work. And then we sent it in, and USCIS said, sure, and they gave an I-94 for that client. But right now, the application of this late filing is somewhat still inconsistent. So I wouldn't say that it's like a guaranteed success. But then at the end of the day, remember, the difference is whether you have to go outside or not. And if you don't have to go outside, then of course that's great. But even if they don't accept your argument and give you an I-797B approval notice without an I-94, you can still re-enter the United States with an H1B visa to activate that petition. I mean, it might be difficult now to do it, and you might have to do a change of status, which is what we're going to talk about afterwards. But, it's not that your transfer petition can never be filed or can never be approved. In fact, your transfer petition has nothing to do with this letter that you're writing, with this late filing, with this grace period. This has only to do with the extension of your status. Whether the petition is approved has to do with specialty occupation, bona fide employer-employee relationship. It has to do with availability of work. It has to do with all these eligibility questions, which we're not talking about that. We're talking only about the continuation of the H1B status and being able to get an I-94 to continue that status in the United States without leaving. So if you win this battle, you don't have to leave the United States. That's all you need to think about. You can still file a transfer. And if you do consular processing, then all of this don't apply to you because you are eventually going to take that approval notice, go outside the country, and then come back in. So how do I use COVID-19? You have to link that to your loss of employment. And the longest I've seen is like 30 days outside the grace period and it's still okay. But right now, since we're just, into the pandemic, and later on, I'm sure in June, in May, in June, and July, people are going to be filing outside the grace period for like maybe 30 days, 60 days, even 90 days. And it'll be interesting to see how USCIS deals with these types of extension. And it's case by case, obviously. So if it's outside the grace period, then it's whatever they say. So we would expect the application of the late filing to be inconsistent across the board. Some people get it, some people don't. So it really depends on the way you argue it. Well, argue might not be the best way to say it. How do you appeal to the emotions of another human being about why not leaving the US is so important to you at this time, even though you're outside the grace period? For example, if your country's on a lockdown, you can't fly back home to go for visa stamping, I think that will be considered, of course. Or if you have some medical conditions that makes you very scared to go to the airport and get on a plane, then that will be considered. Of course, you should probably have medical records to back that up. Or if you have kids who are sick, who can't travel with you. Or if you have any other reason, you have your mother's really old and she's here and she's a U.S. citizen and she's at home and you have to take care of her. Otherwise, no one buys groceries for her. I think that will be considered as well. So anything that you can argue about why it is important for you to not leave the United States, and you're filing the H1B transfer petition after the grace period, use COVID-19. Give yourself the extra chance to get this extension approved. So, and USCIS recently wrote a memo about, allowing late filings of RFEs, late filings of applications. So you can print out that memo and attach it and say, hey, you said I can do this, so that's what I'm doing. So, but definitely still make a case, make a compelling case. And that's where probably immigration lawyers would be best to come in, because we try to, drum up these ideas all day long because that's what we do. It's our job. So, we would try to explore if there's any kind of sympathetic things that we can use, as evidence to get the late filing. And so far, we have been pretty successful at that. So people who are filing outside the grace period typically have not too long, of course. I mean, most of the outside grace periods, like 30 days, within 30 days, most people have been pretty successful in getting a 994. So I think that, well, again, just make the best case. So that's the 60-day grace period. That's what I want to cover about that. Hopefully, I don't know about this, but maybe USCIS will come out with more clarified, rule about the 60-day. But at this time, they are pretty much just going by the paycheck stubs. So if you tell them, hey, this is the last day I get paid, then they usually would calculate, the grace period sort of around that day. And I've seen also cases where even if you don't make an argument about the grace period and you're clearly outside, but only outside maybe like 5 days. So like you got paid on February 5th and you file the application, the transfer petition with an extension request on April 7th. USCIS gives a 994 because they found that you were within. So I would say like maybe quietly they are looking at maybe like a week of buffer sort of around the last paycheck, depending on the officer, of course, to find that you are still within 60 days. So as you can see, this 60 day is kind of, a ever expanding time period. I mean, it's not like a set in stone 60 days. There's no set way to really calculate it, but you can always make the best argument for it. Okay, then the next section, we're going to talk about filing a change of status during COVID-19. because a lot of people, who lost their jobs don't want to sit around and wait for the grace period to be over, or they want to be proactive and file another change of status or file another application so they can wait outside. They can wait after the grace period to be able to find another employer and transfer the H1B over. So I definitely recommend filing a change of status because it buys you at least 6 months if you do a B2, or if you do a F1, then, if you get approved, then that's like a long-term thing. So if you're on H1B or if your OPT ended, you definitely want to file, a change of status. That way it allows you more time to make your next move. And given COVID-19, you can file a late filing. So even if your I-94 has expired, that's a non-protunct situation. So you want to say, hey, I would like a non-protunct, and you need to explain why you didn't file before your I-94 expired. In the H1B situation, you would probably explain that you were waiting for the employer to file an extension, and then all of a sudden the employer went out of business, or the employer was not able to file an extension because of COVID-19. They had a mass layoff. That's unexpected, and that's a matter outside of your control, and therefore you're requesting a late filing of a change of status so that you can wait in the US until when the situation gets better, you can get on a plane and go back home. So that is something that will buy you at least 5 or 6 months. So definitely something that's recommended. Okay, so subject A, I am within my H1B grace period. Should I consider filing a change of status, or should I file a change of status to B2 or F1? Are there any other non-immigrant statuses that I can choose from? So yes, you should consider filing a change of status. Now, if you're thinking that you're going to be employed again, within the next few months, then you probably want to choose B2, because F1, although, within the 6 months, it's probably not going to make any difference, because, the change of status application is going to be pending for a while, probably 5-6 months at least, or 7 months with USCIS, because they're kind of overwhelmed, inundated with like all these extension applications given the virus outbreak. And during that application pending time, you are legal to stay in the United States. You're not work authorized, but you're legal to stay in the United States. So filing for B2 and F1 for the first 6 months is about the same. Now, if you got laid off on H1B and you think that, okay, I have several offers lined up, I just need a few more months, then probably B2 is the best option, because you don't have to pay for the tuition on the F1. With the F1, you have to, figure out the time, you have to be able to, find the school, get the I-20, pay the tuition, which can be pretty expensive. But if you're looking to get back into like another academic program, then F1 would probably be the best option for you to do a change of status. But for this first 6 months, there's not really that big of a difference. But I get asked that question. Should I try to change status to F1, or should I try to change status to B2? And I said, well, if you're going to change back eventually to H1B, does it matter if you want to change to B1 or B1, B2, or change to F1? Probably not, because what you end up doing, as we all know, is 4 months later you find an employer, file a petition, request an extension, and premium processing is back at that time. And then you will decide if you're going to use premium processing. And if you do, and it gets approved in 15 days, then you'll be able to just use that petition, go outside the country and come back to activate that petition. And then you will be back on track. So whether you apply to change to F1 or B2 will be a thing in the past. So it's easier to change to B2 because there are not a lot of documents required compared to F1. So I would say probably B2 if you're thinking about that. And if you qualify for other non-immigrant status, such as O1 or H3 or J1, if you want to do internship programs and whatnot, then you can also change those status. But at the end of the day, what you should remember is that you're filing a change of status application really to buy time so that you can find the next H1B employer, because you have your eyes set on H1B. So it doesn't really matter. All these other statuses that you're filing, it really just to kind of bridge until the next application. So, and remind me to talk about how to change back from B2 to H1B, because I get that question a lot. I don't know, I'm not sure if it's in my notes, but we'll see. Okay, so B, my OPT just ended and I am in my grace period. Should I file a change of status? How long would it last? What should be the start date of the new status? What evidence should I include? Should I file a change of status to B2? Do I have any other options? Okay, so if your OPT is ending, you want to file a change of status. You can do a change of status while you're in the grace period. Now, because the grace period is statutory and you can actually do the B2 from the day the grace period ends, and this is different with H1B because H1B's grace period is not statutory, it's like based on a memo. So if you want to do a change of status, the start date should be the last day you said your 60-day grace period starts. So if you're requesting a 6 months extension, then you'll be requesting from the last day, from the day you were paid. So basically, you remember we talked about the 60-day grace period. So when that day starts is the day you should request, and it should be consistent, request a 6 months change of status to B2. This is a common misunderstanding because a lot of people say, oh, I should just file a change of status from the last day of my grace period on H1B when they lost their job. No, because if you do that, then there's a gap between the day of your last status, the last day of your last status, and then the start date of your B2. And immigration law actually does not allow any gap between any statuses, not even 1 day. So if you say, okay, my H1B ended because I got laid off on March 2nd, and I'm filing this change of status on April 15th, and I'm requesting that my status be changed on April 15th, then immigration will be like, well, what about that, March to April gap? And if you have a gap, then your change of status will not be approved. So you don't want to file an application where you know that it's not going to get approved. So you definitely want to, because it's important later on in the future, if someone asked you, hey, did you overstay, like a custom officer or USCIS officer, you can then present the receipt and evidence of filing. You could say, no, I requested a change of status, and under the law, I am in legal status. And if I'm the officer and I see the receipt and I go, but there's a gap between your last status and your filing start date, so you're still out of status. You want to avoid that from happening. So when you request a change of status, the start date is very important. Think about the start date and don't just put like the day at the end of your grace period if you're on H1B. But if you're on F1, you can, because F1 does have that 60-day grace period, so it does cover it. So that's quite a difference with the change of status. So and when you're on an OPT, should I change status to B2 or any other statuses? Well, I mean, if you qualify for O1, you can always change to O1 if you want to change to J1. But generally speaking, a lot of OPT students approach me because they wanted to wait until the situation gets better so they can get on a plane and go back home. So the best type of status to change for them would be the B2, temporary, visitor status. So, and letter C says, my grace period has ended. Can I still file a change of status application? Yes, you can. Now, with OPT, it's a little easier because you would say, well, I was expecting to go home, and you should probably have like a flight ticket or something. I was expecting to go home, but now with this lockdown, I can't go home, so I'm requesting a change of status outside the grace period. It's unexpected, matters outside my control because of COVID-19. So even though I'm filing this application late, please accept this application so that I can change my status to a temporary status. So that's something that I would do if I'm an OPT student who has overstayed their grace period. But you should probably file your change of status application before your grace period ends, because that's going to be the most advantageous for you. I mean, you don't have to explain any of that. So definitely, if your OPT is about to end and you know that there's no other, I mean, if you're worried about not being able to leave the United States, then you would file a change of status application before the grace period ends, so that you don't have to worry about linking it, to the COVID-19 situation. Okay, D, can I prepare my own change of status application, or should I? I get this question all the time. It's like, is this something I can do? Okay, I'm going to tell you right now, I don't know, because I don't know you. If you have a lot of time in your hands and, if you can read instructions, fine. and you're not worried about, getting it wrong, you can definitely do this on your own, because immigration law doesn't require people to file applications through their attorney. A lot of people, believe that they have to file applications through lawyers. And no. We file it for clients because, first of all, some of them don't want to deal with it, or some of them don't have the time to really look into it, and some of them don't want to do it wrong, or some of them want someone to be able to follow it up, or be able to provide advice, and to be able to communicate with immigration, because we do it all the time. So for us it's kind of easy, but for other people, it could be something of a headache. Like that start date. A lot of people don't know about the start date, and they put the wrong start date, and then it creates problem for them in the future. So can you prepare your own status application? Yes, you can. Should you? I don't know. You should really think about that. I would say, if you're really meticulous with your paperwork, and then you get a consultation from attorneys, and then they look over your paperwork, and then you file it, probably, I think that's fine. But if you're just doing it on your own, and you're not really reading the instructions, or if you're not doing any research before you file the paperwork, I think you'll be filing it at your own risk. So that's today's session. I try to keep it really short, because last time I did an hour, and then I think people were trailing off, and I lost a bunch of audience. So I decided that today I'm going to go through it really quickly. And also, the material isn't as dense as last time. Maybe we tried to cover too much. Last time we bit off way too much than we could chew. So anyway, so now moving on to our favorite section, which is answering people's questions. Oh my God, I already see a ton of questions. Okay, first question is from Akash. I remember Akash, this name. So let's see what Akash says. Is there still any hope for H1B selections as my status is showing submitted? The answer is yes, until the end of the fiscal year. Okay, moving on. Jivan Kishore. Hi, Jack. My question, I have heard that it is legal to stay beyond the 60-day of my H1B period, but cannot work after the grace period. Can you elaborate about the period? Is it legal? That's a good question. So, let's unpack that. There are 3 questions in this question. So, legal to stay beyond the 60-day H1B grace period. It is legal to stay because your I-94 has not expired, but you're out of status, and your employer is going to withdraw that H1B soon, which means your I-94 is going to be canceled after that. Then you won't be legal. So there's a time before employer withdraws that you're legal to stay, but you're out of status. And then after that, you're completely illegal. So we need to know what time period we're talking about. And you definitely cannot work after the grace period, because you need another employer to file a petition for you with an extension request to be able to work for that employer upon receipt under AC 21. So you definitely not work authorized. Can you elaborate about the period? Is it legal? That's all I have to say about that. Let's say that I lost my job this week, and I'm going to stay here, and I stay here for 60 days, and I don't file any change of status application. No application is filed. Technically, I don't know when my employer withdraws the I-94, withdraws the H1B petition, which cancels my I-94. So my unlawful presence could start to count anytime within the next few weeks of my layoff, pretty much. So I'm in the dark. I'm guessing, okay, my I-94 probably is withdrawn, it canceled on this day or this day or this day. I really don't know, because the employer doesn't have to share this with you. So the safest way is to assume that you are lawfully present from the date your employment was terminated. And I think we covered this last time in our last class, that if you assume that, then you count 180 days. During that time, you're not legal here, but there is no punishment for staying here. And if you want to feel comfortable staying here, definitely file a change of status application. But for some people, the filing fee might be too much. They can't afford it, so they decide to stay. And but then, if you don't go over 180 days and you can prove that you depart before 180 days, there's no punishment. But is it legal? It depends on what the word legal means. Is it legal? If I'm going by the plain meaning, it's not legal, but does it matter? Probably not. If you have another H1B petition that's approved And remember, you have to consular process because there's a gap. You didn't file any change of status and you filed outside the grace period. Then you will have a gap and you would have to go outside the country and come back in. And therefore, it will fix the status once you have the employer. So if you're confident that you're going to get an employer within the next 180 days from the day of your layoff, then is it legal? No. But would it work? Possibly. But I would say that's a kind of a risky situation, and I would never want to put myself in that boat where the anxiety. I would just file a change of status application. That way I know comfortably that I'm legal in the United States. Next question. Benit lawyer. If the company paid the pending money from their severance package, can I use that as a 60-day start period? Possibly. But it would depend on what the evidence looked like. Because if you're submitting evidence that says this is severance, then USCIS could say, well, that's not really part of keeping you in status. It's not a salary. So it gives the officer room to make decisions one way or another. So on this issue, it would really have to examine the document. So I have a payroll record, and I ask my employer to, amortize my. I don't know if amortize is the right word, but sort of distribute my severance pay into a paycheck situation. And I'm willing to take a little bit less of a severance to make that happen. Then I think that would look more solid than like a separate piece of paper that says, this is your severance and you got paid severance on this day. And then you're trying to use that day as the day your 60-day grace period starts. I think that's going to be less advantageous compared to if you have it sort of woven into your pay stubs. That's what I'm thinking. Next question. Praveen Kumar. Hi, Jack. I have a question. The question is, my wife is currently with me on H4 status. Her H4 is set to expire by August 2020. Got H1B extension approved until August 2022, but haven't filed for extension because we want to change her status to F1 instead of extending her status. She has a 920. Is it ideal for us to file her change of status from H4 to F1 or extend her H4 status based on my H1 extension? Our initial plan was to go to Canada for F1 stamping, but with recent restrictions, we're thinking no longer option. Please suggest around. Thank you. Okay. I don't really know how to answer that question. I would say either way is fine. You can try to change to H4 at this time. You can also try to change to F1. I would probably do an H4 because that's more straightforward and you don't have to pay the school. And then once you get the H4 or while you're waiting for the change of status to be approved and the border opens up or the consulate opens, the border is open right now for F1s, by the way. But if you don't have an F1 visa, you can't really do that. So let's say if the consulate is open, then you can abandon the change of status to H4, which kind of holds you in status until then, and then go for F1 and come back. So that's the concept of like filing a change of status to buy more time, like we talked about in topic number 2. So I would say probably F1, and probably H4, because if you file a change of status to F1 and later on has to abandon it and go get the F1 visa anyway, then that means you have to pay the school first, and you have to get the I-20, and you have to prove financial ability and all of that. So if you can prove H4, which is a lot easier than F1, then that's the application I would choose. But either way, I think it's the same, because eventually you're just waiting for the consulate to reopen and go and get an F1 visa and come back in. So whatever in between you file, it really matters very little. Okay, Swapnil asks, hi, I'm on H1B and staying with my family in Phoenix. My visa is 6 years, maxing out on May 25th. What will be the option available for me to maintain legal status in the US? Do I need to quit my job to maintain status? How do you maintain status by quitting your job? No, that would never happen. So in your situation, the only way is to get an I-140 approved to extend H1B beyond the 6th year. If you want to be work authorized after that, then you have to find another work authorized status like O1 or B1 and live H1B, or maybe L. I don't know if L is even possible if you haven't worked outside the country. So that's a tough question, and without a lot of facts, I can't really say much. I would say the only way to extend an H1B beyond the maxing out time is to have an approved I-140, or if you have a perm pending for more than 365 days. But in this day and age, not a lot of people have that. So usually it's an approved I-140. So let's do next question. Can you keep getting the work authorization if a case is administratively closed in cancellation or removal case? Okay, we're not going to be able to cover that. I'm sorry, cancellation or removal is this huge giant beast that is an application that you file in immigration court to stop deportation. You have to be living here for 10 years. So I would say you can probably renew work authorization if your case is administratively closed. That's what I'm thinking. But don't quote me on that because I have not done deportation defense in the last 2 years. But I can definitely find out for you if you email me because my team has a deportation defense attorney that goes to court all the time, and they'll probably be able to find out about that. My gut reaction is yes, because whenever you get a work permit for a pending application, even if it's administratively closed, like asylum, you would still be able to get the work authorization under it. That's my gut reaction. But if I'm wrong, please don't kill me because I'm not sure because this changes sometimes. Anyway, we'll move on. Have you get any H1B receipt yet? Yes, I get H1B receipts all the time. So move on. Can we apply for H1B extension from outside the USA considering current situation? I think there are two things. There's H1B petition extension, which doesn't require to be in the US, and there is the visa, which requires you to go to the consulate. So when you say H1B extension, I'm not sure which one you refer to, but I think that if you're for the H1B petition extension, you don't need to be in the United States. That's the employer's job; they file that. Okay, so next question: will the previous employer notify USCIS regarding the termination date? Yes, they will withdraw the petition, and USCIS takes the withdrawal date really as the formal official date that your employment is terminated. So yes, they do notify USCIS. Swetha, can I convert the B2 back to F1 if I'm on F1 unemployment period? If I'm on F1 employment period, I'm trying to think because I don't understand what that's asking. And this happens a lot. Sometimes people ask a question, I'm like, what are they trying to say? And in my mind, I'm like translating what they're saying. I think what this person is saying, he is on OPT, and even though he didn't mention OPT at all, he's on OPT, and he has 90-day unemployment coming up, and he wants to change to B2, and then later on he wants to return to OPT. Not possible. But later on, if B2 is approved, can he file another change of status for another academic program? Yes, if B2 is approved. So there's a bridge application. So that's possible. Furkan, is premium processing applicable for COS? Yes, it is applicable for COS, but depends on what kind of COS. Usually like an H1B COS, there's premium processing. But if you're like COSing from like H1B to B2, then there's no premium processing. So in certain instances, and you can look up the instructions for, I believe it's form I-914, the I-907. It's the premium processing form. And in the instruction, it'll tell you which type of applications are eligible for premium processing. Okay, Parth. I am currently on STEM OPT until July 2021, currently on furlough, unpaid leave for up to 90 days because of COVID-19. As per DSO, it is unemployment. Oh, that's the DSO's position. I don't think it is. Meanwhile, my H1B is picked up this year. Will USCIS consider late filing of H1B in this case because of COVID-19? You're not late filing the H1B. If your H1B is picked up in the lottery, you have to file before June 29th. There's no late filing for that. You've got to file it on that day. I think what you're asking is, would USCIS say that you're being furloughed is out of status and not change your status from F1 to H1B? That's my translation. And if that's the case, you have to make an argument that being furloughed is not unemployment. And there are a lot of literature online that's available for that. Furlough, by definition, is you're still on payroll. You're just not going to work and your pay stopped. But you're not unemployed. You're just on furlough. They have a different word for it for a reason. I mean, if this is unemployment, why don't they just call it unemployment and call you unemployed and not call you furlough? So the word furlough, look up the definition, And then, look up different literatures to support that. That's not unemployment. So, and given that, it's COVID extreme situation, I'm sure USCIS will not say, hey, you were furloughed during that time, so you didn't maintain status and, blah, 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 and we're not going to change your status. I doubt that that's going to happen. Okay, so Vineet has another question. If the company paid the pending money for the severance package, can I use the 60-day start period? I think we already answered that question. If I already started apply H1B to B2, can I withdraw the B2 within 60 days of grace period or later? Yes. That's usually what people do. If I was laid off as a part of an annual RIF, I'm assuming I can't use COVID-19. What's RIF? Nothing comes to mind. RIF? Sorry. Okay, we're going to have to move on because you already asked a question. So let's let other people ask their questions. Furkan, you already asked a question too. Everybody's asking multiple questions. Could you recommend day one CPT? Do you foresee any issues with that? I don't recommend it. I don't not recommend it. I don't caution people. I just think that, you can do it. It's legal. But you would have issues with changing status, and you definitely want to consider that, as you're doing day one CPT, because if your employer don't want to do consular processing, then you have to go for stamping, and for some people that's like a large anxiety because especially people from India, they don't want to go for stamping. They think that going for stamping is the worst thing ever. If that's the case, then doing CPT, might require a little bit of thoughts. But, at the end of the day, even if you get change of status approved, without using CPT, at some point you still have to go for stamping anyway. And using day one CPT is not a reason to get your H1B visa denied at stamping. So one really has nothing to do with the other, pretty much. Okay, so let's move on. Viren Kataria. Jack, I was laid off on my H1B. Can USCIS question your intention for COS to B2 to H1B, from B2 to H1B, considering that B2 is just visitor status? Why would they? No. As a visitor, you can always get a job and qualify for H1B and go back. So you're not working, you're just looking for work. And most people, on B2 change of status, they're not going to change back to H1B within the United States. They're waiting for the border, the consulate to reopen so that when they get a new employer to file a petition while they're waiting for the B2 change of status, they take that petition, go out and come back in. And they either already have an H1B visa to allow their reentry, or they go to the US consulate, applies for another H1B visa, and then come back in. So not a lot of people would file another change of status from B2 to H1B after the B2 is approved. Because after the B2 is approved, that's already 7 months from when you file a change of status. And then after that, if you file another change of status to H1B, it's going to take another 6-7 months for them to get back to you. And during that time, you're not work authorized. No employer would wait that long for you. So what employers will do is say, take that petition, go out and come back in. That way we can have you on payroll right away. We're not going to wait for another B2 to H1B change of status. That simply takes too long. So the scenario described here is less realistic, I think. But so what you need to know is, if you're waiting for a change of status, what you're really doing is, buying time, and then later on use the approved petition, go outside and come back in to activate the H1B status. Okay, Shruti, past 60-day grace period, file CO to the B2, identity shows valid until 2022. What does that mean? That means it's valid until 2022, unless your employer withdraws it. Has my previous employer withdrawn H1B, or do I have to assume? Of course, you're assuming that they withdrew, unless they tell you they didn't, which would be great. That means you could go back and work for them if you want in the future. Okay, next question. Jimmy Yang. I worked for a staffing firm and the project was finished. The last paycheck is $214. They said they didn't revoke my H1B. If I can find project myself, they can continue to hold my visa. Is that feasible? I guess it depends on what find projects myself mean. Do you have to bring projects to the employer? You have to go out and meet clients? Or, that hardly is in the job description, I would imagine. So I don't really know what it means, but what that means is, what you're saying is that if you don't find another employer and your last employer welcomes you back or like wants you back, you can always go back because they have not withdrawn the H1B petition. That's how that translates in my mind. But as far as feasible to find your own project, I don't know what that means, so I can't really comment on it. Next question, Bassnet. If COS to change of status to B2 filed late after OPT grace period is declined for some reason, when will unlawful presence accrue? Oh, good question. So technically, if you're looking at this from a very legal perspective, unlawful presence starts to accrue when your grace period ends on your OPT. But then you file another change of status. If you request a non-protunct and they approve it, there is technically no unlawful presence because they backdate the approval to the last date of your grace period on your OPT. Now, while the application is pending, you still accrue that many days of unlawful presence until you file a change of status with a non-protunct request. But this discussion is largely meaningless because it's only a few days of unlawful presence, and like we talked about, if it's less than 180 days, it really matters very little. So that's what I would say about that. Virent, Catalia. How would you show the evidence for flight tickets for COS to B2 as there are no flights right now? I mean, you can book a flight in the future, like in July or August. There's no flight then, or September. Because if you request 6 months, you can always, get an airline ticket that late, or you can just simply state that you will be getting an airline ticket. And USCIS could RFU for airline or some kind of ways to return, maybe like in August. Then at that point, maybe there will be flights available. So to file a COS, you don't necessarily have to attach the flight. But for some officers, if you don't attach or make a very firm assertion that you will leave the United States, they could RFE you. They could say, hey, B2 is a visitor status. You have to demonstrate that you will be leaving the United States. We don't have that in the file, so we will be asking you for it. Okay, next question. Psyche Chloe Lai. I don't know if it's a Psyche. I'm just going to say Psyche. Psyche Chloe Lai. That sounds like a really catchy name. I want to say it over and over again. Jack, I was laid off and I have applied for COS from H1B to F1. Okay, if unfortunately I don't find a new employer within 6 months and COS is complete, can I still continue looking for employment on F1? Yes, because you're cap exempt for 6 years. We covered that in the last class. My H1B doesn't expire until 2021. Thanks. So the expiration date doesn't matter. You're cap exempt for 6 years. So you can always find another employer, even if the COS has completed. And we covered that today. Not in the notes, but remember, you can always file another H1B because you already won the lottery. Next question, Javine, posting on behalf of a friend. My parents have come on B2 and now they're stuck. Read somewhere that USCIS waived fees for B2 extension. No, USCIS would never waive the fees, but there are fee waivers that you can file. But for visitors, their position is that you came here, you told us you have money, you told us that you were able to pay your way as a visitor in the United States. Now you're gonna ask us to waive the fees. So they're usually pretty tough on that. So I would say no, but there are fee waivers. I don't know if it applies to extension of status, but it's only $370. Just get a credit card. They take credit cards now. Tianlian Huang, will be the period before the B2 application gets rejected considered overstay? Will the period before the B2 application gets rejected considered overstay? Oh, what does that mean? I feel like Sherlock Holmes. Will the period before the B2 application gets rejected considered overstay? No, because B2 application is pending. So first of all, overstay has two different things. There's unlawful presence and being out of status. They're both overstay. So you have to decide, because these two are different concepts. Unlawful presence starts to accrue when the B2 change of status application is denied. And before then, no unlawful presence. But perhaps you were out of status. But since being out of status, there's no punishment, only unlawful presence. So I'm going to say yes to that question if we think overstay is just out of status. But there's no punishment. So whether the answer is yes or no, it makes no difference. It's just a really fun legal discussion that really amounts to nothing. Okay, so next question. Reduction force. I don't know what that means. FB chat is horrible. Doesn't reflect all the edits. Sorry. Well, I guess technology isn't quite there yet for us to have like a really great discussion about change of status. Swatha, I think that's a new person. Okay, good. How soon before my F1 visa becomes invalid? I use up all my unemployment days. Should I apply for change of status to B2? I have 30 days remaining on my grace period. The answer is simple. Yes, Swetha, please file a change of status if you want to stay here longer. I mean, if you're not going home, I mean, but you can't really go home right now. It's a lockdown situation. So yes, file change of status. Arati, are there any chances USCIS extending the grace period? This is what I covered last time. I think that they are already extending it without saying that they extend it, because they're going to get on all the conservatives' nerves that they're extending this grace period. But they already extended it. They said if you're affected by COVID-19, you can file it late. What that means is if I'm outside grace period, I am just going to connect it to the virus and say why I'm filing late. And if the USCIS accepts it, isn't that in effect extending the grace period already? In my opinion, that is extending the grace period. And we covered this last time in our class. So you shouldn't miss any class. Just kidding. Anyway, next question. Basnet Depeche. If we travel outside US on pending COS, it's automatic denial. It's abandonment. It's not denial. It's abandonment. You just let it go. Like it's not denied. USCIS hadn't made a decision on it. So there's kind of a legal difference, but not that big. So, okay, abandoned. How does it work in COS to B2 if we don't receive decision until 180 days? You just continue to stay because you have a pending application. The 180 days is kind of just an internal deadline for USCIS to approve the petition. You're not out of status. I mean, you're out of status, but you're not accruing lawful presence after 180 days. So there's really no punishment, even if that happens. I know it's really unnerving when that happens, but legally speaking, there's no ramifications. So it's like, well, it happens. What are you going to do about it? Not much. So I would say that's also another theoretical legal question that really, there's no consequences to be observed. Vinit asked, I-140 approved back in 2016. Employer withdraw that as petition as layoff. Yes, employer can withdraw petitions anytime and lay off anyone at any time. In that case, what happens if I consumed all 6 years of H1B, and does my employer have to file a new I-140? This is a good question, and this is beyond the scope of what we're covering today because this gets really technical issues about H1B, AC21 extensions beyond the 6 year. My understanding is that even if prior employer withdraws the I-140, you can still extend H1B beyond the 6 year because it was already approved before. But if you have another employer who wants to take over that I-140 and continue your green card application, they have to start from scratch. They have to do the prevailing wage, the recruitment, the perm, and then they do the I-140. But they can use the priority date from that I-140. So that's a huge advantage for like people who've been waiting for a long time. But in terms of the processes, they do, like the perm process do have to be restarted. That's my understanding. But we haven't really seen it. Well, actually, I did. There was a case in 2019 where we did file an extension, but there's been no employer that took over, the I-140 yet. So we haven't seen that. But that's an easy part. But extending the 6 year, I think that the new memo from 2017 says that you could extend your H1B beyond the 6 year, even if the prior employer had withdrawn the approved I-140. Next question. Karthik Pala, can I apply to change of status from H1B to F1 like 5 days before? Before what? And do I need to pay the service fees while applying to change of status? Yes, always pay the fee. Can you apply 5 days? Sure. I mean, the mail should get there like in 2 days and USCIS will receive it. They really look on the day of like arrival. So if it arrives, they haven't checked it in, they'll consider it in. But what if it gets rejected? What if you have the wrong fee? What if you forgot to sign? Or what if you do the form in the wrong way and then it gets rejected? Not denied, okay? There's a big difference between rejected, which means never received, and denied, which means they received, looked at it, and they said no. That's denial. Rejection is like they didn't even put it in. They just like threw it out. It's like, okay, well, this is missing, so gone. A rejected packet is never filed. So when you get it back, it's like 2 or 3 weeks later, and you're already outside the grace period. Then you're going to have to argue why you're late and do a late filing or a non-proton. So should you wait till the last 5 days? It's up to you. I would not. I would give them at least 2 weeks. So if there's any issues with rejection, at least you have a chance to get the thing back or refile it if you check your bank account and the filing fee has not been cashed. You know that there might be an issue, and just to be safe, you file another one before the rejection comes back. But that's always a good question. How late in the game do you want to wait until you file a change of status application? Well, I really it's up to you. If everything is smooth and there's no rejection, sometimes USCIS wrongly rejects petitions or applications too. Even if you have everything, they could still reject. But then you have to make an argument that they rejected it wrongly and you really filed it on time. So it just becomes double the work. But either way, since you can't really avoid that, I guess don't wait till the last minute. Give yourself more time. Okay, so Arif Ahmed. My wife applied for COS to F2 to F1. It's been 6 months. Raised the inquiry. Also expired 45 days. We talked to the level 2 officer. The officer is saying it takes 8 or 9 months, but USCIS website says 3 to 5 months. The USCIS websites are I don't even know how they get those data. I think they just made it up. Sometimes they say, I'm like, that's way too quick. There's no way, I haven't, on average, my cases don't. Where did you get that 5 months from? And then, so the wait time actually from F2 to F1, I would say 6 or 7 months. I just got one approved this week. This week. And I checked the filing day. We filed in November. And it was F2 to F1. So I would say 6 months is probably an average for that. It was a pretty straightforward case, so I don't know if there's any issues with that. And USCIS, this goes back to what we were talking about earlier. Should you file your own change of status application? I can't prove this to be true, but I do think that USCIS pay more attention to cases that are filed by law firms if it's prepared well, because they don't want to have to deal with attorney complaints. But if you don't have a lawyer on the file, on the application, then I don't know. They might not. But if it's prepared really well, obviously, there should be no doubt that it should be approved quickly. But sometimes things just take a while. That's what I would say about that. But thank you all for tuning in. Again, follow me, choose C first, and then join my group so that we can have more wonderful discussions about this. And we'll see what happens with the executive order. I don't think it's going to get extended or rearranged or changed in any way. I think that there are much bigger fish to fry for these distraction tactics, and I think that the executive order is going to be what it is right now, and it's not going to affect a lot of other people. So we are going to say goodbye now, and thank you all for tuning in and share this wonderful Sunday evening with me. All right, well, you take care, stay home, and be safe. Hey, Javon. I can't take any more questions, but you can message me directly. And if you join the group, you'll see in the announcement how to make an appointment for, quick questions and things like that. So I hope to hear from you all. Have a good evening.